Today, we are going to start a series of sessions on Indian polity and constitution. Initially, we will be focusing on the fundamentals of Indian polity and constitution. These are the topics we will be discussing in this series of sessions. Today, we will be discuss about Supreme Court of India. The history of Supreme Court. The Supreme Court of India is the highest judicial court and final court of appeal. India is a federal state and has a single and unified judicial system with a three-tier Supreme Court, High Court and subordinate courts. Regulating Act of 1773 established the Supreme Court of Judicature at Calcutta as the court of record with a full power and authority. The Supreme Court at Madras and Bombay were established by King George in 1800 and 1823 respectively. The High Court Act 1861 created High Court for various provinces and abolished Supreme Court at Calcutta, Madras and Bombay. These High Courts had distinction of being the highest courts for all cases till the creation of Federal Court in India under the Government of India Act 1935. Then after India attained independence in 1947, the Constitution of India came into being on 26 January 1950. The Supreme Court of India also came into existence and its final sitting was held on 28 January 1950. Article 125 to 147 in Part 5 of Indian Constitution deals with the organization, independence, jurisdiction, powers and procedure of Supreme Court. The Indian Constitution under Article 124(1) states that shall be a Supreme Court of India constituting a Chief Justice of India and until Parliament by law prescribes a larger number of not more than 7 other judges. The jurisdiction of Supreme Court of India can broadly be categorized into original jurisdiction, appellate jurisdiction and advisory jurisdiction. However, there are other multiple powers of the Supreme Court. The organization of Supreme Court. Let's look into the organization. Here organization means the number of judges in the different years from the formation of Supreme Court until this 2020. The year 1950, the number of judges was 8. At the same time, 1956 it was 11, 1960 14, 1978 18, 1986 26, 2009 31 and 2019 34. Currently, the Supreme Court of India includes 34 judges, including Chief Justice of India. The appointment of judges. The judges of Supreme Court are appointed by the President. The Chief Justice of India is appointed by the President of India after consultation with such judges of the Supreme Court. The other judges are appointed by the President after consultation with the Chief Justice. The qualification of judges. Let's look into the important qualifications of judges. He should be a citizen of India. He should have been a judge of High Court or High Courts of Succession for 5 years, or he should have been an advocate of High Court or High Courts in Succession for 10 years. He should be distinguished jurist in the opinion of President of India. The Constitution has not prescribed a minimum age of appointment as a judge of the Supreme Court holds office until the attains of age 65 years. Let's look into the salaries and impeachment procedures in Supreme Court. A judge of Supreme Court can be removed from his office by an order of the President of India and must be supported by majority of Parliament, both in the Rajya Sabha and Lok Sabha. The Judge of Inquiry Act 1968 regulates the procedure relating to removal of judges in Supreme Court by the process of impeachment. No judges of the Supreme Court had been impeached so far. Recently, there were two important cases reported that relating to V. Ramaswamy 1991-1993. At the same time, Justice Deepak Mishra 2017-2018 were the two cases, but these two cases were filed in the Parliament. The salaries, allowances, privileges, leave, and pension of the judges of the Supreme Court are determined from the time to time by the Parliament of India. Then let's look into the Collegium System of Supreme Court of India. The Collegium System exists in the Supreme Court, at the same time the High Courts of India. The Collegium means the system is under which appointment and elevations of judges and lawyers to the Supreme Court and the High Courts. Each collegium is composed of 5 people, including the Chief Justice of the Supreme Court, if in the collegium in Supreme Court, at the same time the Chief Justice of High Court if the collegium in the state oriented or the High Courts. And besides this Chief Justice, there will be 4 additional members, that is the senior judges of the respective court. There is no mention in the collegium either in the original Constitution of India. Then let's look into the different benches of the Supreme Court. Here there are 2 divisions, division bench and constitutional bench. Here division bench means the number of judges include in 2 or 3. At the same time, the constitutional bench means the judges, number of judges included in this constitutional bench 5 or more. Let's look into the jurisdiction and powers of Supreme Court. Supreme Court's powers or jurisdiction can be divided into 4: original jurisdiction, writ jurisdiction, appellate jurisdiction, and advisory jurisdiction. So, which are the important points included in original jurisdiction? Original jurisdiction means the federal dispute center and one or more state. In this case, the Supreme Court can engage this case and 2 or more state. The dispute must involve law or fact. At the same time, it's a dispute between different units Indian Federation. Then the writ jurisdiction. As we know that we have a lot of writs, mainly habeas corpus, mandamus, prohibition, quo warranto, and certiorari. These are the writs. Regarding these writs, the Supreme Court can engage the powers and their function. The Supreme Court is empowered to issue writs. Writ jurisdiction of the Supreme Court is not exclusive because the High Courts also released and also issue the writs. Original jurisdiction in the sense that an aggrieved citizen can be directly entered to the Supreme Court of India to file the writ. Then the next is appellate jurisdiction. Appellate jurisdiction means the appeal, and here's appeals against the judgment of the lower courts, appeal in the constitutional matters and appeal in civil matters, appeal in criminal matters, and appeal by special leave. The last one is advisory jurisdiction. Advisory jurisdiction means under Article 143 authorizes the President to seek the opinion of the Supreme Court in 2 categories of matters: on any question of law or the fact of public importance, on any disputes arising out of any constitutional matters, and the last point including advisory jurisdiction is treaty, agreement, and other similar instruments. Thank you for listening to this session.